How to file a simplified dissolution of marriage in Florida. Filing for a dissolution of marriage with dependents in Florida involves several steps to ensure a smooth and legally sound process. This guide will walk you through the key aspects you need to consider and the steps you should take when filing for divorce with dependent children in the state of Florida. Step 1. Understand the grounds for dissolution. In Florida, a dissolution of marriage, which is the term used for divorce, can be granted on the basis of either no-fault or fault grounds. The most common ground is irretrievable breakdown of the marriage, which is a no-fault reason. This means that you don't need to prove that either party is at fault for the divorce. In cases with dependent children, the focus remains on the well-being of the children and their best interests. Step 2. Residency Requirements. Before filing for a dissolution of marriage in Florida, you or your spouse must meet the state's residency requirements. At least one of you must have resided in Florida for at least 6 months prior to filing. Step 3. Gather necessary information. Collect important information regarding your marriage, finances, assets, debts, and child-related matters. This includes 1. Personal information, full names, addresses, and contact information for both spouses and any dependent children. 2. Marriage information, date and location of the marriage, as well as any prenuptial or postnuptial agreements. 3. Child-related information, details about the dependent children, including their names, dates of birth, and current living arrangements. 4. Financial information, information about assets, debts, income, and expenses. This includes bank statements, tax returns, property deeds, and any other relevant financial documents. Step 4. Parenting Plan and Time-Sharing Agreement. In cases with dependent children, Florida requires the creation of a parenting plan that outlines the arrangements for time-sharing, custody, and decision-making responsibilities for the children. This plan should include details about how you and your spouse will share parental responsibilities, including where the children will live, visitation schedules, education, healthcare, and more. Step 5. Child Support Calculation. Child support is a critical aspect of divorce cases involving children. Florida has specific guidelines to calculate child support, taking into account factors such as each parent's income, the number of children, healthcare costs, and childcare expenses. Ensuring accurate financial information is crucial to arrive at a fair child support arrangement. Step 6. Filing the petition. To initiate the dissolution process, you will need to file a petition for dissolution of marriage with the family court in the county where you or your spouse resides. This document outlines your grounds for divorce, the parenting plan, child support calculations, and other relevant information. You will need to pay a filing fee, but if you cannot afford it, you may be able to request a fee waiver. Step 7. Serving the other party. After filing the petition, you need to serve your spouse with a copy of the petition and other relevant documents. This can be done through a process server, a sheriff's deputy, or another authorized person. Proper service ensures that both parties are aware of the legal proceedings. Step 8. Response and negotiation. Once served, your spouse has a specific period to respond to the petition. This response might include agreements or disagreements on the terms presented in the petition. Negotiation, mediation, or collaborative methods can help both parties reach mutual agreements on issues such as property division, alimony, and child-related matters. Step 9. Court Proceedings. If you and your spouse are unable to reach agreements through negotiation or mediation, the case may proceed to court. A judge will review the evidence, hear arguments, and make decisions on the unresolved issues. Step 10. Finalizing the divorce. Once all matters are resolved and the court approves the agreements or makes decisions, a final judgment of dissolution of marriage will be issued. This legally ends the marriage. If you have dependent children, the judgment will also include the approved parenting plan and child support arrangements. Filing for a dissolution of marriage with dependent children in Florida can be a complex process. It's advisable to consult with an attorney who specializes in family law to ensure that your rights and the best interests of your children are protected throughout the process. Legal guidance can help you navigate the intricacies of divorce and provide the support you need during this challenging time.